Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll look at 3 questions in relation to failure of gifts, which falls under wills and the administration of estates in FLK2. Let's dive in. Here's the first question we tackle today. Attestators will contain the following gifts. I leave all my listed shares to my niece, including shares in Amazon and Apple. I leave my Van Gogh painting to my nephew. The testator recently passed away. Both the niece and the nephew are over 18. At death, the testator owned Amazon and Tesla shares, having sold the Apple shares, and the Van Gogh painting was exchanged for a Monet painting 2 weeks before death. What is the legal position in respect of these gifts? A. The niece receives all listed shares the testator owned at death. The nephew receives nothing, as the specific gift of the Van Gogh painting has adeemed. B. The niece receives only the Amazon shares, as the reference to Amazon and Apple limits the scope of the gift. The nephew receives the Monet painting by substitution. C. The niece receives no shares, as the class of listed shares has changed. The nephew receives the value of the Van Gogh painting. D. The niece receives all the shares, but the nephew receives nothing because the gift of the painting has lapsed. E. The niece receives only the Amazon shares, and the nephew receives the Monet painting by analogy. You can pause the video and think about it. The best answer is A. The niece receives all listed shares the testator owned at death. The nephew receives nothing, as the specific gift of the Van Gogh painting has adeemed. The gift of all my listed shares is a general gift, not limited to Amazon and Apple, even though they were named. Therefore, all listed shares owned at death, including Amazon and Tesla, pass to the niece. The gift of the Van Gogh painting is a specific gift, and since the painting was no longer part of the estate at the time of death as it was exchanged, it has adeemed. The nephew receives nothing, unless the will provides otherwise, which it does not. Let's look at another question very similar to the first question. Attestators will contains the following gifts. I leave my Van Gogh painting to my nephew. I leave all the money in my account maintained with ABC Bank to Diana, my grandchild. When the testator dies, the nephew is over 18, believed to be alive, but cannot currently be traced. Diana is 12 years old. The Van Gogh painting, ABC Bank account and its funds are still in the estate. Which statement best describes the legal position? A. The Van Gogh painting passes to the nephew, but is held on trust until he is located. The ABC Bank funds pass outright to Diana. B. The Van Gogh painting gift lapses due to uncertainty, and the money gift fails as Diana is under 18. C. The Van Gogh painting passes to the nephew and is held on trust for him until he is found. The ABC Bank funds are held on statutory trusts for Diana until she reaches 18. D. The Van Gogh painting gift adeems as the nephew is missing. The ABC Bank funds fall into residue as Diana is a minor. E. Both gifts fail, the nephew is untraceable and Diana lacks capacity to receive a legacy. The best answer is C. The Van Gogh painting passes to the nephew and is held on trust for him until he is found. The ABC Bank funds are held on statutory trusts for Diana until she reaches 18. The Van Gogh painting is a specific gift. It is still in the estate, so the gift is valid. The nephew is believed to be alive but untraceable, so the gift does not lapse or redeem. Instead, it is held on trust by the executors until the nephew is located or a Benjamin order is sought. The money in the ABC Bank account is a specific pecuniary gift. The account still exists, so the gift is valid. Since Diana is 12 years old, she cannot take the gift outright, but the funds are held on statutory trusts under the Trustee Act 1925, sections 31 to 32 until she reaches 18. Here is the third tricky question. Attestators will contains the following gifts. I leave all the money in my account maintained with ABC Bank to Emily, my daughter. I leave all the money in my account maintained with XYZ Bank to Paul, my grandchild. At the time of the testator's death, Emily, aged 34, predeceased the testator. She is survived by 2 children and her husband. Paul, aged 12, also predeceased the testator in an accident. He had no children, but had a brother named Peter. Both the ABC Bank and XYZ Bank accounts are still part of the estate. Which statement best describes the legal position? A. Both gifts lapse and fall into residue. B. Emily's gift is saved by the anti-lapse rule and passes to her children. Paul's gift lapses. C. Emily's gift is saved by the anti-lapse rule and passes to her husband. Paul's gift lapses. D. Paul's gift is saved by the anti-lapse rule and passes to his brother. Emily's gift lapses. E. Both gifts are saved by the anti-lapse rule and pass to the named beneficiaries next of kin. The best answer is B. Emily's gift is saved by the anti-lapse rule and passes to her children. Paul's gift lapses. Gift to Emily, the testator's daughter. Emily is a direct descendant of the testator. Under Section 33 of the Wills Act 1837, if a child or remoter descendant of the testator predeceases the testator but leaves issue, the gift does not lapse. Instead, it passes to that issue per stirpes, that is, split equally between her 2 children. Gift to Paul, the testator's grandchild. Paul is also a direct descendant, so Section 33 could apply, but it only operates if Paul left issue, children. Since Paul had no issue, Section 33 does not save the gift, and it lapses. Paul's brother Peter is not issue of Paul, so he cannot inherit under S.33. The money in the XYZ account will fall into the residuary estate. This table summarizes the legal principles. There is a distinction between specific and general gifts. A gift of all my listed shares is a general gift. It doesn't matter if the exact shares mentioned in the will, like Apple, were sold. Whatever listed shares the testator owns at death, like Amazon and Tesla, will go to the named person. If a will gives a specific gift, like a Van Gogh painting, but the item is no longer owned when the person dies, the gift fails. This is called ademption. The beneficiary gets nothing unless the will says otherwise. If someone is left a gift in a will but can't be found, the gift doesn't fail. The executors must keep it safe in trust for them. If needed, they can go to court to get permission to distribute the gift in a different way. If a minor, under 18, is left money, they can't receive it directly. The money must be held in trust for them until they turn 18 under the Trustee Act. If the person named in the will is the testator's child or grandchild and they die before the testator, the gift won't fail if they had children of their own. It will pass to those children. But if they had no children, the gift fails and usually goes into the residue. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.